Okay, sorry for getting started just a little bit late here. This is Preston Clark. I am the co-founder of Law Insider. I'm Electra's partner in the launch of oneSaaS, and we have been for the last 2 days at the Future Contracts Miami event where we officially launched oneSaaS, and we invited you all to be here today to talk to you about what it means to bring oneSaaS into your organization. So we're having a couple of technical difficulties. We'll have Electra join here in a second, but I'm going to share my screen. We're going to talk through this process. Electra and I may be sharing a device for this, so if you hear us sort of jump in and out, we're passing the device. We're here at a WeWork in Coral Gables, Florida. Electra's flown 23 hours door to door to be with us from Cyprus. And we had over 1,000 people registered for this event. So it looks like there's about 450 on. So thank you all. We are going to be monitoring the Q&A. We'll be monitoring the chat. So we will, and we have a team, Dory's here too. So we will be reviewing this, processing it, responding to feedback. So please continue to submit questions as we go, and we'll do our best to respond as we go. Jenny, hi, Shane, Anthony, Richard, Alan, Joshua, Todd, so many of you here. Thank you so much. Okay, first thing, let me just do an audio check, just since I'm back on now. If you don't mind just confirming that audio is good and that the screen is good and you can see my screen, maybe most importantly. Good, okay. Thanks, Mary. Oh, it's quite echoey. Okay. We will fix the echo. This is sort of the WeWork downside. I apologize. We may get stuck in echo land, but good call out. Okay, so let's go. It looks like Electra is here, and I will go through the agenda, and then we'll start getting into the details. So the housekeeping I think we have done. We're gonna run this an hour or 53 minutes. Electra is going to talk about how the vision for oneSaaS really is through the foundation of oneNDA and the massive global success that it experienced. So we'll talk about the relationship, the methodology. We'll talk about why oneSaaS, and some of that is very tangible, which is we did lots of surveys and we asked lots of you where you wanted to start, and cloud services agreements were definitively top of the list. We're going to talk about how we did it. The methodology should be very important to you because we're asking you to adopt something that is not your work, but it is steering committee developed. And so how this was created is really important, how we did it. We'll then get into the very tactical, like maybe you've downloaded it, maybe you already have it in your hands, or maybe you don't. But it's more than just a single document. And I'll be very honest, it's more complicated than oneNDA. You would expect it to be, but it's not just complicated because it's longer. It's complicated because there's more decisions for you to make about how to implement this within your organization. We'll walk through the resources. We'll do Q&A. But as I mentioned, feel free to continue asking questions throughout. I'm going to go on mute now. Electra, are you good to go?
Hi, everybody. Sorry about that. I hope that you can hear okay now. Please let me know if not, and thank you, Preston, for saving the day there. Okay, so
I will drive the slides.
Yeah, cool. Great. Okay, so thank you, everyone. Cool. So I was just in the middle of talking about how this all started. So effectively back in 2021, I was running a legal consultancy called TLB. And during that time, the business grew exponentially. We were effectively offering outsourced contract review services to in-house counsel. And we did a deep dive to figure out what it is that we did during the course of that year, and found that 63% of the agreements were NDAs.
You get some feedback? Okay, sorry.
Yeah, no, yeah, cool. Yeah, 63% of the agreements that we'd reviewed were NDAs. That's it. That's all we'd done. And obviously this was an insane amount of redundancy. And so effectively, I'd figured out that these high volume, very low risk, hardly litigated agreements were just completely unnecessary because everyone was reviewing the same things just in different words. And so we decided to do something about it. And the rationale there was that the NDA was not the problem in and of itself. The problem wasn't the NDA. The problem was the fact that everyone was using their own form. And so I took to LinkedIn and I asked people why on earth we're doing what we're doing. I said that it would be a great idea if we just all adopted a single standard that we used as our own. And this had an incredible response. We had companies and lawyers contacting us from across the world. Someone says they clearly remember that post. That was the beginning of everything. And today, oneNDA has 6,000 adopters. We estimate that it gets signed around 10 million times a year, which is incredible organic growth, considering that this just happened through LinkedIn and through a community of lawyers that really, the vision really resonated with them. But oneNDA has always been about more than just a document, and we're acutely aware of the fact that we need to get critical mass here for this to be really successful and for standardization to take hold. And so we were really excited and just beyond grateful for the opportunity to be acquired by Law Insider. And Law Insider gave us access to an audience that we could have only ever dreamed of. And this was, of course, incredible for the adoption opportunity and the exposure opportunity that we didn't have previously just through organic growth. So it's been an incredible journey since we joined Law Insider. And the first thing we did after the acquisition is turn to the community, because oneNDA has always been about community. And we asked them, okay, what do you want to see next? And there was a resounding steer towards the SaaS agreement, which is, of course, not surprising. And SaaS contracting is completely broken. There is a lot of repetition in the clauses that we will see. I'm sure that you, if you're reviewing SaaS agreements, you would agree. And there are a few reasons for that. And this doesn't just apply to SaaS, but to all routine agreements. Firstly, they're artisanal. Everyone drafts in their own way. They are not interoperable. So every time someone gets an agreement, they need to kind of decompile it to figure out whether it aligns with their preferred positions. And of course, they are proprietary. So every organization has their own. They treat them like intellectual property, and that has stifled innovation. And of course, the scale of the problem is huge. There are over 30,000 SaaS companies worldwide, 1,000 contracts signed per SaaS company. Each organization that buys SaaS applications buys around 130 of those a year. So that means that there are 30 million SaaS agreements that are negotiated annually. So you can just see what the scale of the problem is here. And the methodology was really important. So the way we did it was, unlike oneNDA, not manual, because we had access to Law Insider's data. We accessed almost 1,000 SaaS agreements, and we broke those down into different clause titles. And we found that over the 1,000 agreements, there were 819 different clause titles. But then we used AI again to boil those down into the substance. And we found that those 819 agreements were actually made up of 52 substantially different clauses, which highlights that there's about a 94% overlap here. So it also highlights the fact that standardization is already happening. We're just not talking about it. You know, people go to Law Insider. Millions of people go to Law Insider every year to access the same clauses that they tweak slightly. Standardization is already happening. And just as a sidebar, this is the exact reason why reviewing routine agreements every single day could feel like Groundhog Day. And it is, in fact, the perfect combination of stressful and boring, because they're not standardized, you're not quite sure whether a clause says what it should say. So you have to be extra vigilant while you're reviewing an agreement, while your eyes are glazing over because you've seen it all before. So just from a professional, personal satisfaction aspect, it's not great, but it also does create a huge redundancy and cost and damaged relationships and just unnecessary dealings that standardization could very elegantly fix. So the way we did it was to get a steering committee, which was comprised of some incredible law firms and in-house counsel. And we asked them to look at those 52 functions. And a function is effectively a thing that the clause does. And what we wanted to do is decouple the clause from the function, because as lawyers, we do two things with our brain. Firstly, we assess whether a function should even be in there, and then we assess whether we like the language. And that's not something that we wanted to bog our steering committee down with. We wanted them to only think critically about whether a function should be in there. We also wanted to remove any bias, because when you see language that you're familiar with, you can sometimes think that something should be there, but actually it's not. Critically, if you assess that, it doesn't need to be there. So we wanted to remove that bias. And today, on Monday, we launched oneSaaS, which was effectively a culmination of over a community of over 300 lawyers that came together to offer feedback. We had over 600 comments that we either incorporated into the agreement or sent to a graveyard document, which is where the clauses or the positions that you might be used to seeing went to die, with a rationale as to why, so that you can then use that as a negotiation tool. If the other side pushes back on why something isn't in there, you can show them that actually this wasn't just a flippant decision, but something that we very thoughtfully decided not to include. So how do we access oneSaaS? Preston, can I hand this over to you to show how you access oneSaaS and to talk everyone through the
absolutely. Absolutely. So if you all are familiar with oneNDA.org today, that has been sorry, one second. Okay. So if you're familiar with oneNDA.org, it's been a very easy process to type in some information. An email comes to you via email, or a document is directly downloaded to your web browser. And we're making this more sophisticated. And so today, if you go to lawinsider.com, and by the way, you should all do this. If you go to lawinsider.com/standards, you will find a hub of all of the oneSaaS, all of the Law Insider standards, including oneNDA unilateral, all of the multi-language versions. But the oneSaaS, of course, is there, predominantly featured as well. And there's really two ways we want you to interface with these documents. One of the ways for you to do that is by just downloading the agreement, filling out the form. You'll get a nice automated email from Electra. It'll give you a bunch of instructions, video content, etc. But another way to do this is by scrolling down and seeing the different variations of oneSaaS. And this includes cover page. This includes, and actually, let me do this. No, you're good. I'll go directly to where we want to be. So I'm in oneSaaS. I can go into Explore, and now I'm on the oneSaaS page. Of course, the video is there, but what you will find is a really good resource of all of the questions, some of which we're answering today, some of which we won't get to, that relate to the very nuanced application of the tool. But when you get to the middle of the page, and this is really, really important, what you're going to see is what Electra refers to as a suite of that surrounds oneSaaS. And you can press the download button and you will have the suite. But as we unbundle it, what it means is you have a data processing agreement, you have an SLA, you have a counterparty onboarding guide. These are tools that you will use to facilitate and ultimately adopt oneSaaS in the way that is most appropriate to your organization. I do want to point you to where it says view standard terms. And this is really, really important because it may relate to how you plan to adopt oneSaaS. And so I'm going to click here. What you will see now is a link that allows you to incorporate oneSaaS by reference. And so if you are like me, you have your own order form. You have you default to incorporate by reference. The order form has sort of key terms, dollar amount, etc., whatever it may be. You may call it an order form, you may call it a cover page, whatever it is. But this is both just something that you can use to reference and understand what are the core terms, sort of the unchanging terms of oneSaaS. But it is also as something that you can link to, and that your counterparty will then see, because so much of the benefit of oneSaaS, like the benefit of oneNDA, is that this is not yours. And this is a novel idea. As a former in-house attorney, like we take a lot of pride in the crafting of our own documents, but as Electra very clearly articulated as it related to non-disclosure agreements and in the creation of oneSaaS, we are all just redrafting variations of the exact same agreement over and over again. And so the purpose of standardization is to say, no, we are using oneSaaS specifically so that you don't assume that this is drafted or crafted in a way that is unduly biased towards my organization or unfairly dealing with yours, but in fact, it is a global, publicly adopted, steer committee developed standard. Okay, so let me go back now. I want to do a little more orientation to the Standard Hub, because these are tools and resources that are important to you. This video, if you're sort of coming out of this webinar today saying, okay, I got it, I understand how it was made, I understand why it was made, I understand where to download it, but now I need to figure out how to get this into the organization, how to populate it. This is all here. So you can watch this video. You can go to the graveyard and understand which parts of this are excluded, or how it is that different aspects of oneSaaS were arrived upon, like why this part that is always in my cloud services agreement is excluded. How did you arrive at that decision? These are things that will give you peace of mind in adopting it. This should also give you peace of mind, because invariably we don't expect that every counterparty is going to receive this and immediately know what oneSaaS is. oneNDA has been around for 3+ years now, and so we had a great interaction with someone from Salesforce here in Miami yesterday that said that they just received oneNDA from someone and they approved it right away because they had heard of it, they knew Electra, they know what it is. It'll take oneSaaS a year, 2 years to reach the level of global acknowledgement and understanding that oneNDA does, which means in the meantime, there's going to be a lot of your counterparties that end up back on this page saying, what is this? Who created it? Who's the steering committee? What other organizations have adopted it? Why are these things included? Why is it structured the way it is? And so you want us to do that heavy lifting for you. You want us to be a partner to you in telling the story of oneNDA, of oneSaaS, of oneDPA, whichever version of a standard you are adopting. This page also has great resources, including the adopter directory. Many of you may already be familiar with this. This is really important. We will give you information on how to become an official adopter, but this is a way where if someone wants to see what other companies are already on the adopter list, they can go do that. Why is that important? We are creating a community. We're creating a community of like-minded lawyers and in-house teams and organizations that believe that these types of agreements can be standardized. So having your name here goes a long way, but it also gives your counterparty confidence that they are not the first ones down this path, that this is something, so if they accept this, they're not the first ones to ever accept an agreement of this type and nature. So these are the tools that we make available to you to use, but also the tools and the sort of marketing or accessibility that we'll be sharing with your counterparties so that they understand the implications of this agreement type. Electra, can I pass it back to you?
Sure, thank you. Thanks, Preston. So, so that's how you access the document. It's, as Preston said, this is a oneSaaS suite. And I'm now going to walk through the actual document. Sorry, guys, I'm working on 2 devices, so it's slightly hard. So that's it. Okay, cool. Thank you. Okay, so this is oneSaaS. The drafting here is very simple and very plain English, and we've tried to structure this in a way that's going to make this as user-friendly as possible. So the way it works is that you've got your cover page, which is where you introduce all your variables. So if you're familiar with oneNDA, you understand the structure. So you put in your variables. These are broken down into general terms. There are drafting notes, quite detailed drafting notes for each. Of course, when you've got your own version of this, you can delete your drafting notes and fill in just the details so you've got a clean version. I won't go through the substantial elements here, so just from a legal drafting perspective, but if you do have questions, please ask those, and it's very helpful for me to hear the questions so that we can then address those in an FAQ document and even introduce things into the graveyard. So, this has only been live for 2 days, and we are looking to you guys to tell us what areas you think are unclear. So please keep those questions coming. Then we have the second section here, which is services and usage. We appreciate that every SaaS provider will have their own terms when it comes to things like services and usage, and then even below when it comes to payment terms and data usage and limitation. So the way we've structured this document is that you've got your key terms with your variables. You can either choose to have the key terms and use these as your order form, or if you've got your own order form, you can use your order form alongside the key terms. And we did this because there are smaller SaaS vendors that may not have an order form, or there are bigger SaaS vendors that like the elegance of just having one document where everything lives. But there are others with really established ways of working where their sales team will simply access the order form and send it out and maybe incorporate terms by reference. So that's why we're giving you the flexibility to either use your own order form or the key terms. If you do use your own order form, you also need to use the key terms. So it's not, you can't completely descope the key terms. And the reason for that is because these terms here are definitions within the agreement. So this won't work without you filling in something. And it could just be not applicable or see order form. And in the video, which is on the website, I do a full walkthrough of how you would populate each of these fields. So please watch that after this to familiarize yourself with that substantial element of the drafting. Just something that I wanted to draw your attention to is that here, the drafting note will say, for example, that this section is required, but this section is optional. So there's this notion of optional clauses, which you can completely remove from the document. This did not exist in oneNDA, but you can remove a whole section. So you can literally just delete this bit. But here, this is required because the term documentation is referred to in the body of the agreement. So if you were just to delete this, then the body of the agreement wouldn't work, because wherever there's reference to documentation, there's no definition associated with it. So it's broken down into these sections in the key terms. And then beneath this, you will see that there is a field for special provisions. So in version 1 of oneNDA, there was no flexibility. So you would just send out oneNDA, and the other side was not allowed to negotiate it. And of course, they were allowed. And if they did want to negotiate it, the ask was that you remove all reference to oneNDA, logos, branding, etc., because we didn't want to erode the trust that people may have in the document and the fact that it is just the document without changes. In the second iteration of oneNDA, and this was off the back of feedback we'd had from people around barriers to adoption, where they said, you know what, I love oneNDA, but I can't accept it because of the definition of affiliates. And we had lots of internal conversations, quite philosophical ones, around the notion of standardization. And we agreed that standardization is underpinned by a set of core principles. Like, one of the core principles of oneNDA was that you shouldn't really be including a penalties clause, because that's not appropriate for the purposes of run-of-the-mill routine NDAs. And we didn't want to introduce that as an option. So we introduced the special provisions in version 2.1 of oneNDA, where you're now allowed to introduce your own special provisions if you have those, as long as they do not go against our core principles, which are also published on the oneNDA website. And so the idea is that you can customize the agreement to suit the nature of your services or the nature of the agreement in question, but as long as you're not eroding the standard. Now, with oneSaaS, that was slightly harder, because there aren't any hardcore rules yet around SaaS agreements, and they're almost less controversial than NDAs, I think. And I'm looking to you to give us feedback if you have ideas around that, and if you think that something should go in the core principles of oneSaaS, where there's something that says this is something that you should not put in a SaaS agreement, then I really would love to hear that. So we've introduced a special provisions field here that you can use to either add provisions that don't appear in the body of the agreement or amend provisions that aren't exactly aligned with what you need. But we ask that you do that sparingly and only when it's absolutely essential. And we've put it here in the drafting note, because the whole point of standardization and the whole point of you guys going through the rigmarole in big organizations to get these documents adopted is for you to avoid negotiation. And actually yesterday, when we were having our event, we had someone who came from the construction industry who was talking about they have had standard forms for nearly 160 years, but now those standard forms come with a 100-page amendment, which is exactly what we don't want. We don't want to have a standard so that we can create friction through amendments of that standard. That's not the point. That's not why we're doing this. So we appreciate that this is quite loose guidance around how you can use special provisions, and we will continue to iterate and monitor it. What we're doing is new, and like any product, we need your feedback to make it better. So if you've got any thoughts around that, or ideas on how to make that a bit more stringent to maintain the quality of the document, then please do share. And finally, we have supplemental documents. So this is where you can incorporate other documents by reference or by addendum. So here we've got the order form. Again, this is really detailed, and I won't go through every single detail here. Please do read it. And again, if you've got any questions or if you think anything is unclear, let me know. But you can add your order form, which is your own document. You can add an add-on services set of terms. So we've actually drafted this for you. And if you scroll to the bottom of the document, you will see that there is an add-on services addendum. And this is for professional services that you're offering that aren't support services. So if you need to do that, then you can add this addendum to it. Then we've also got an SLA here. Most of you will have an SLA. We have drafted one SLA for you, and it's attached to this document. So when you download the document, you'll get one SLA with it. You can either use your own SLA, or if you don't have one, you can use one SLA. Then you've got the trial and beta use terms. There was some debate around whether this should be part of the baseline terms, but lots of SaaS vendors who are on the steering committee said that they don't offer trial and beta use. It's not appropriate for them, which is why we descoped it from the baseline, but we've introduced it as a separate addendum. Data protection addendum, it's really common to incorporate DPAs into your SaaS terms. What we're saying here is that you can, of course, use your own DPA, or you can use one DPA. And just a note on that, for one DPA and for one SLA, we've ensured that the terms are completely interoperable with oneSaaS. So you won't have to do that cross-check. And one DPA is quite well established. It's been around for a couple of years now. And we've had really great feedback about it. And it is widely used and accepted. So it's a document that you can trust. And then we've got security measures, which again, just we've had feedback from the steering committee around how security measures is something that they often publish online. So here you can incorporate a URL if that's appropriate for you. And of course, other supplemental documentation. So for example, you might have a data retention policy to introduce here. So again, you can either attach it, or if you publish these documents online on your site, you can include a URL. Then you've got your parties and execution. With oneNDA, we had this up top. We've had input usually from lawyers in Germany saying that the signature block needs to be beneath the key terms in order for it to be appropriate for that jurisdiction. But again, you know, we're not too precious about where this lives. We just want to make sure that everything is aligned, you know, and everything is familiar. So when the other side receives it, there's no friction around, oh, is this actually oneSaaS? And then we have the standard terms. So Preston showed you a web page earlier where these standard terms live. And the idea is that if you are incorporating your standard terms by reference, you're doing this by virtue of this cover page. So at the top of the cover page, it says that the agreement comprises of the contents of this cover page, including key terms and supplemental documentation, and that by executing the cover page, you are incorporating these terms by reference. But for the purposes of your download, we have attached those standard terms in the same document. So you would either delete these or just include them as a reference copy if you like. But what we're saying is that you shouldn't be redlining these. These, if you want to make any amendments to the standard terms, you would do those by virtue of the special provisions field. So do not redline these. These are not meant to be redlined. These are meant to be a reference copy. And actually, the way we're envisaging this working operationally is that you would incorporate the standard terms by reference, and they live on a web page. So that also eliminates any unnecessary negotiations. And that is it for the document. I'm just going to go and see if there are any particular questions here. Yes, okay. So are these solely definitions? No, so they're not solely definitions, not at all. Sorry, that's a really good question. So some of it is operative and some of it is definition. So like, for example, governing law, operative, dispute resolution method, operative. Here you would choose what option fits best, but documentation is a definition. So yes, that's a good question. Is this meant to be for B2B or B2C or both? Very good question. It is B2B. It's meant to be B2B. B2C would be a whole different beast. We may tackle that in the future, but this is B2B for now. What about financial regulatory addenda? Yes, we have had this comment from the steering committee. Dora, this got brought up. We would encourage you to use your own annexes for now, but in future, this is something that we would love to tackle. David, that is embarrassing. Thank you for bringing that to us at our attention. We'll look into that. And as I said, we launched this 2 days ago, and there will be a snagging period. So lots of people will find little snags that we will pick up. Is oneSaaS DORA compliant? If so, is there a mapping tool to show how it is compliant? No, we're not saying that oneSaaS is DORA compliant. When we were doing the steering committee, we said that people would have their own DORA addendum. So that's how you would make it compliant. Have you incorporated feedback from pure SaaS customers? So the documentation must be static or no hyperlinks whatsoever. Yes, and just to say that the definition of documentation there can be amended to suit your needs. So the wording that we have in here is amendable, so you can change it. No, so the steering committee, there's a question here about how the steering committee was made up. Good question. The steering committee was made up of a mixture of SaaS vendors and customers. So we tried to get about a 30-70 split. So 30% was SaaS vendors. We need the SaaS vendors to adopt this, and 70% was customers. I'll let you, Preston, handle that next one.
Someone asked about how we make money. It's a good question because you want to make sure that this is free forever. So Law Insider, if you're not familiar, is a primarily free contract database, clause database. We've been around for 10 plus years. I started it very early in my career. And we, like a Duolingo or lots of tools of this nature, we monetize on the margins. And so we have 10,000 active paying customers that use as superpower users advanced features of Law Insider. And so the monetization of this for us is not something that you will experience or feel in your adoption or use of oneSaaS or oneNDA, but we sell tools that are researching contract clauses, AI-powered contract review tools, and the brand benefit to us of being the leader in a standard is that you hear about those and you see those, and it's good business to offer us a service like this. So that's the short answer is just that doing good things for free helps build our brand, and we've been at it for 10 plus years. So this isn't a novel idea for us. We've been the vast majority of our users don't pay us, and it turns out that's still a wonderful business model. Let me look at a couple more of these. Electra, we have one. Is this adaptable for healthcare tech?
It's not adaptable for healthcare tech. It is adaptable for healthcare tech. You can adapt this agreement to any industry that you like. And if you find that there are areas that aren't covered, again, this is why we have a community platform. We'll send a link around later with some more guidance around the other documents that you can use. There's more ancillary documents that you can use. So yes, it can be used for other industries.
Major SaaS normally won't agree to DPA terms, diverting from their terms, while smaller might. How can that be standardized?
I mean, one DPA is a standard that you could use. There will always be the issue of people pushing back and wanting their terms, and that's why we have things like the adopters directory. And this is a movement to get people more on board with the benefits of standardization. Having said that, if you did need to incorporate their DPA terms by reference, then you can absolutely do that in this agreement.
What was the rationale regarding not excluding data protection breaches from the limitation of liability?
Yeah, it's contentious, so it would cause lots of friction, and we discussed this at length during the steering code. So if you did need to incorporate that, you can do that through the special provisions or by amending the appropriate sections within the agreement. So we're setting the bar in terms of what's market standard based on the feedback we had from this quite large community of lawyers and the in-depth debates around what makes sense and what doesn't. But if something doesn't work for your use case, you could try and change it. You could change it in the fields within the key terms.
It looks like this could be used for services other than SaaS. Is there anything in particular that makes this SaaS exclusive?
Francesca, that's great. That's a great observation. And I think this just goes to the point that I was making earlier around standardization of routine agreements. A lot of them are very similar. So you could use these terms, but it is designed for SaaS. Frank Adrian, is there a simple legal design version to explain the main terms to a buyer layperson? This all exists. So there is a one-pager that we have, which is an explainer of what this does that you can share. And again, after this webinar, we will send out an email that shares all these documents.
And if you go to the oneSaaS page where it says download the suite, that document that Electra just referenced is there.
Yeah. Derek, hi. No, we don't have that information just yet.
Because it's today.
Today's the launch event. So yeah, no, but hopefully after this webinar, yes.
We had 1,300 downloads of oneSaaS in the last 36 hours. So the good news is it's coming, Derek. Give us a few more days though.
Yeah. Tim, I love that question so much. Yes, absolutely. And people, I was talking to people at the conference over the last 2 days, and a lot of them use oneNDA as a negotiation tool. And they say, well, this is in oneNDA, so it's market. And yes, absolutely. That's the dream.
I want to, if I can hijack this just for a second, Electra, there's a couple other things that I want to say. So what's coming next is that there's a complexity, just being very blunt about it, there's a complexity to you taking this document, adopting within your organization. There's certainly like an institutional complexity of getting buy-in from stakeholders, whoever may need to decide, your general counsel, CFO, whomever are the parties that you need to work through. But there's also an operational complexity, which is this document, it has a lot of instructions. What will be coming out in third week of March, we're announcing this a legal week, along with something else I'm going to tell you about, is a builder for oneSaaS, a builder for oneNDA that will also be completely free. And so instead of downloading a document, configuring it manually through Microsoft Word, you will be able to populate it. It will have the if-then logic built into it. So it will be exactly as you need it to be step by step. And then that will produce the template that you need tailored to your organization, aligned with the rules and guidelines that are sort of native to the document, but that today exist very much as instructions rather than software-enabled logic rules. So that is coming. That's number one. And then number two is that there's going to be well, there is already, but we haven't sort of fully announced it into the market yet. For every standard that we launch, there's going to be a corresponding AI-powered playbook that you can download as a document, as a spreadsheet, or you can use for free via Law Insider, that allows you, when you are receiving third-party cloud service agreements, to defend the principles of oneSaaS, but specific to your organization. So I appreciate that your cloud service agreement may have an auto renew, but you may not accept auto renew, and that's totally fine. But it'll give you that sort of configurability, because we think for each standard that we launch, there ought to be a corresponding set of rules that govern how you deal with those documents when they come from a third party. And in the cases of a mutual NDA, that may be a very mutual interaction, very equal interaction, but something like the cloud services agreement that may look very different from the document itself. So I wanted to share those two things because they're coming up at Legal Week, excuse me, in New York in 4 weeks from now. Electra.
Cool. And just to piggyback off what Preston just said, what we're trying to do is also expand the notion of a standard, moving from just a basic standard document, just a static document, to a framework, because we want to enable you to uphold the standard even when the other side does not accept it. And until we reach that critical mass, that will be the case, but we want to enable you to do that. And so this AI tool is exactly the answer to that. And, with the advancements in this technology and the infrastructure that Law Insider has given oneNDA and the future standards, that's really what we aspire to do, to give you a full suite.
Yeah, Julian asked a really good question. Will the oneSaaS builder have the ability to upload a version sent to us to see what has changed or tempered aside from the variables? Not the builder won't, but the AI review will. So this capability is also launching. And the basics of it is that you will have your standard in Word. You will upload what you receive back. It will do an immediate compare, and it will demonstrate what has been changed or modified.
Great. Any other questions? No?
Scott, once you download it, you will get a package of Word documents. There'll be a couple of PDFs that are sort of instructional, sort of less interactive documents. But yes, you will get emailed a package from Electra, auto-generated. It'll have videos. It'll basically be a packet of resources you need to analyze the document and the standard for yourself, and tools to help you adopt it within your organization.
Great. Thank you all. We'll probably be hosting another few of these over the next few weeks, because we want to hear your feedback. So as I said, please do share that.
Lawinsider.com is the web address. I have to just pause for a second. If it seems like we are rattled today, we are incredibly rattled today, because we just came out of the biggest single event we've ever had as an organization. We had 300 plus lawyers with us at the University of Miami School of Law for Future Contracts Miami. We have slept basically none in the last 4 days to get everything up and running. The conference was outstanding. The launch has been exceptional, and Electra has not slept in 2 days. So we are here. This document is great. We want you to use it, but we are tired. And it's been a long run. So we hope that you love it. We want your feedback. We are on this journey. I've been toiling at Law Insider for, I think it's close to 12 years now. Electra has been at this with TLB to oneNDA to now oneSaaS for almost 10 years. So you're going to see a lot more from us in the standards movement. And we would love your feedback as we go along here.
Thank you, Preston. Thanks for saying that. Good. Thanks everyone for coming. Really appreciate your support. As always, we would not be here without you. So yeah, keep the support coming so that we can do more of this.
We'll send out the recording.
Yes, we will. Yeah, and the slides. Thanks everyone.
Thank you.